In a setback for Amazon and Flipkart, a division bench of the Karnataka High Court has dismissed their petitions against an antitrust probe, thereby allowing an investigation by the Competition Commission of India to continue into allegations of anti-competitive practices by the two online retailers. Noting that the appeals against the single judge bench order were devoid of merit, the bench refused to quash the CCI probe at this stage. A body of MSMEs, Delhi Vyapar Mahasangh, had filed a complaint before the CCI claiming that Amazon and Flipkart's links with preferred sellers foreclosed options for their competitors, based on which CCI in January 2020 had ordered a probe as it prima facie held that there was a case against the online retailers. However, an interim stay was granted by the High Court in February 2020, which continued till last month. CCI will continue probing allegations of predatory pricing, deep discounting, preferential seller listing, and exclusive partnerships against Amazon and Flipkart, as the division bench has refused to stall last month's order by a single judge bench, which did not stall the investigation. CCI had urged the division bench not to stop its probe against Amazon and Flipkart, claiming that any further stay on probe will have serious consequences for the economy. Appearing for the CCI, Additional Solicitor General Madhavi Diwan argued that there is no civil liability at this stage of the probe against the online marketplaces. She said that even if the CCI inquiry revealed any malpractices, Amazon and Flipkart will get a chance to present their side of arguments before the Competition Commission of India. CCI is probing Amazon's alleged links with Appareo and Cloudtail and Flipkart's alleged links with WS Retail and Omnitech. Diwan pointed to the stay imposed on the probe by a single judge bench of the High Court in February 2020, while sounding the dangers of a possibility if the allegations turned out to be true eventually. She argued that not probing the two online marketplaces for nearly 1.5 years might have damaged the economy irreparably, indicating that many MSMEs have already been pushed out of business during the pandemic. CCI maintained that while there are numerous benefits of e-commerce, but it needs to be kept competitive and online platforms are meant to be neutral. Opposing arguments on inapplicability of competition law on Amazon and Flipkart, Diwan argued that online marketplaces are very much a part of the production chain. She also submitted that competition law itself is an evolving subject, arguing that it is incorrect to conflate online marketplaces with malls, as the former are not passive players. Taking an example from malls, she pointed out that shops at strategic locations have higher rentals than those located at the far end of the mall. She noted that the differential rent practice in malls is transparent, as mall owners do not dictate customer behavior, claiming that this is where physical marketplaces differ from their online counterparts. She argued that anti-competitive agreements may not have been made in writing, but may be operating with a tacit understanding, which requires a thorough probe.